Hello everyone. Hello everyone. We will be studying about the women director and resident director today. So let's understand about it. The focus section is 149 subsection 1. So under 149 basically we are understanding the composition of the board of directors in a company. So there are different types of company. Broadly we can say they are public company and private company. Then in the case of a public company, minimum number of directors required is 3. And in case of private company it is 2. And in case of one person company it is 1. And minimum number of subscribers to the memorandum of association. Subscribers are the people who are the initial people who want to incorporate a company and want to do business together. So they are the few subscribers can be the directors as well, right? Or may not be. So these are the people who form the company, right? So they are the promoters or subscribers to the memorandum. So these are minimum 7 people are required to form a public company, and 2 members or 2 people are required to form a private company. Maximum number of directors, be it a private company or a public company, it will be 15. Company may appoint more than 15 directors after passing a special resolution. So members meeting will be called and more than 75% or 3/4 majority is required to pass a pass a special resolution in the members meeting, and with that the members consent, the directors can be appointed at one time more than 15 in a company. Reasons will be there for appointing more than 15 directors. Maybe geographically the business is so much huge that in different around the globe the people are required to manage it or administer it. So obviously that's why the directors are required, or the directors are required for other reasons, right? There are different types of directors under the Act. We are focusing today on the women director and the resident director. So let's talk about resident director and the women director. So women director has been given under section 149 subsection 1, rule 3 of the company's appointment and qualification of directors rules. These companies require to have at least one women director on its board. So every listed company or every public company having paid up share capital of greater than or equals to 100 crores or turnover of greater than or equals to 300 crores. Limits need to be remembered. Every listed company, it's said, not a listed public company. So if a private company listed its securities, debt securities will be considered as a listed company and have to comply with these provisions, right? So it's a listed company. Every listed company or every other public company, unlisted public company, having a paid up share capital of greater than or equals to 100 crores or turnover of greater than or equals to 300 crores. So either or condition complied, public company has to comply with the provision. Act says minimum one women director is required. If the company has more than one women director, there is a well complied section. For a newly incorporated company, a 6 months time has been given. From the date of incorporation, 6 months within that, if the provisions are attracted, then these companies have to appoint the women director. For the purpose of calculating these limits, the paid up share capital figure and the turnover figure will be taken into consideration, will be taken from the financial statements of the company. So which financial statement to refer? The latest audited financial statement which is available will be taken into consideration while deriving the limits or checking the limits which are mentioned under this rule. In case of intermittent vacancy, the board of director is the authority. They will be filling up the intermittent vacancy in case or in place of women director. So reasons for intermittent vacancy may be that the women director is no more want to continue, or she resigned or vacated his office for other reasons, or died, incapacitated, or removed, whatever be the case. So intermittent vacancy will be filled up by the board of directors. When it will be done? Earlier but not later than immediate next board meeting, so in the upcoming next board meeting, or 3 months from the date of such vacancy, whichever is later. So we should understand that why government has done this, that why women directors are to be appointed mandatorily in these companies. or why women is being given this reserved kind of a thing, right, in this act. It's not a reservation for women here, actually. Women are actually needed in the corporate world. There is a dearth of it. That in the board, only men dominated board and a women and a men dominated board, right? Only men dominated board versus a women and a men having working together a board. Which will be the most performer or the very much well performer will be the next one. That is the combination of both the women and men working together will achieve more growth and objectives of the company. And it is being globally researched and proven that women are better leaders, and they obviously have more patience and more perseverance, and they are also the best motivators to the other people in the company, means the one level below board and also the other departmental heads. So obviously women are also better in managing the finances of the company, right? So that's why women are encouraged to join the board of directors around the globe. And it's a better way or a one or the good way to have or complied with other corporate governance requirement of the company. So obviously women are required to be appointed in these companies, and and also they should be encouraged. So that's why these provisions are there given under the act. Now moving into the resident director. So resident director section 149 subsection 3 speaks about the resident director. There is a two different term, that is the residentship and the citizenship. We are here talking about just the residentship, not concerned about the citizenship. So every company who is incorporated in under this act or under previous act, which is governed by the Indian laws, they have to comply with this provision. So all companies are there. So no exemption to any company. At least one of the directors of such company shall be staying in India for at least 182 days or more than that in a financial year. So it's an annual compliance. Every year the compliance need to be done. So financial year, every year need to be seen the residential status of various directors of the company, and need to determine that at least this condition is being satisfied. That at least one of them, like at least suppose three directors are there in the company, so at least one is staying in India for around 6 months or more, right? That is 182 days. And for a newly incorporated company, obviously, if it is company is incorporated in the month of September or July, few months have already elapsed. So this 182 days limit for a year of incorporation, the first year, shall be proportionately adjusted. And if all the directors of the company are the resident directors or they are staying in India throughout the year, the section is well complied, right? But at least one should be staying in India, other can move around the globe, no issues. So this is about the women director and the resident director. Hope everyone has understood it, and thank you for your patient listening.